Now, with great respect, I invite Professor Dr. Upendra Baxi, sir, to begin today's special lecture under the Vidhisankalp series. Sir, we eagerly look forward to your thoughts.
Well, thank you very much. If I may say so, I don't look forward to it at all, but I look forward to the discussion. Thank you for your very kind introduction, Vice Chancellor Sharma and Compare and Saksam Patyan, dear friends, distinguished participants. And I'm more interested in discussion, so I'll be brief in my presentation, maybe 30, 35 minutes. And I would greet cordially the faculty and the Vidhisankalp and whose auspices this program of discussion has been arranged. And I'm supposed to, what shall I say, do a double engine theme. Part one is jurisprudence of law and morality, and part two, law student academics, a relook into the aptitude and accomplishment. I'm very glad, as I said, to be part of this program. But I think part two is more a matter of discussion between the learners of law and would be pursuing legal careers in future and their anxieties and concerns. I'll try to address briefly some of this, but mostly I'll talk about jurisprudence of law and morality. In fact, the Assam NLS is a second home to me, and I have not been able to visit Guwahati for quite some time. I promised I could not come due to various reasons, but I certainly will be with you in the near future. Quite an infliction on you all, and to be ready, I'll come. And I think I feel at home with Guwahati, with the Assam University, National Law School, because I have so many friends. And your predecessor in office, Dr. Sharma, Mr. V.K. Ahuja, Dr. V.K. Ahuja tried his best to get me there, but I couldn't come. But I was constantly a nuisance to your faculty, and you are on the board with an article on Kishore and the Bharati. It was a rare book, a very distinguished collection of essays. But I was too much demanding on the editors, and my apologies for it. It has come out very nicely, and I've learned a lot from other essays in the book. And if you haven't read it, it is your publication. I commend it to you very greatly. I would also say that as a Vice Chancellor of two universities, I had the great pleasure of beheading them both. But as a Vice Chancellor of two universities in India, I have taken the view that NSS is an integral part of education, not an auxiliary feature. And it is not often realized that the community outreach that is performed by NSS is not merely part of education, but of great social service. So I'm very, very pleased. I've rarely been asked under the auspices of NSS. And I know the consequences of branding NSS as marginal. In some states, the difficulties even recognition and even pension for the services. I intervene and make sure that they do it. Somehow the feeling goes down that NSS is marginal to legal education. Please allow me to correct this with great respect. It is integral, as I said, to legal education. And I'm very glad, Mr. Vice Chancellor, that under your guidance, the institution of NSS is flourishing. Now, coming to the first part of my theme, I said double engine. So I'm not very good on double engine themes, as I say. But I'm coming mostly to the word morality, what law and morality, the first part. a very well calculated assault, first part and second part. But I try to relate the two. But coming to the first part, as well known perhaps, the word you must ask yourself how often does the term morality occur in the Constitution? The useful test of your knowledge of Constitution. And I think it occurs 4 times in the Indian Constitution. Twice in Article 19, fundamental rights, and again in fundamental rights, twice in Article 25 and 26. The rest of the time, the Constitution is silent about morality. And first question is, does this silence indicate that the rest of the Constitution is not a moral document? It's not suffused with morality of any kind. That you look only at these 4 articles where morality is mentioned. I think my opinion on the take is this, and you may discuss with me later, that it would be wrong to read Constitution by these 4 mentions. It's not article specific. If you think carefully, the Constitution is resoundingly an ethical document, and therefore it continues to be invoked by courts in many different contexts, not only religious freedom, or Article 19, or it extends to what is considered reasonable restrictions under Article 19. What is reasonable is for the law to decide, but not only for the law to decide. Morality comes into the picture. So there is an ethics of constitutionalism, if I may say so, where it comes in a big way. I'm a little confused about the idea of law and morality, but if I understand it, the people who thought about it had concerns with differences between legal positivism and morality and natural law thinking. For natural law thinking, it was integral, morality was integral to natural law thought. In other words, it was ethical through and through. It was imbibed by values given by nature. Now, whose nature am I? What is the meaning of nature in natural law? And there are 2 answers to it. One is theistic natural law, theistic, religious natural law. And other is secular natural law. In theistic natural law, the word of God prevails. What we call personal law systems. That's a very bad example in a way, because I don't believe in the title personal law systems. Law is public or not at all. So I stumble every time. I still stumble. Because I don't know what is meant by personal law. Is always public. And personal law is also public law. But that apart, I would say in positivism, law was very strictly considered. And images of law in legal positive is a vast area. So if you believe that law is the word of God, it's a different story altogether. You have to do or die, obey it or disobey it, and take the consequences. God Almighty gives the law and punishes its transgressions. This thought is present all throughout natural law. Somebody famously said, Rudolf Stammler said once, is we can think of natural law with a changing content. It changes over time. That's a great idea. Let's get discussion about what is the changing content. You can't change the word of God if you believe in God. Therefore, natural law does not quite correspond, for example, to dharma. Dharma is, as you no doubt know, 3 or 4 things. One is swadharma, the dharma of the self. The second is kula dharma or jati dharma. The third is samanya dharma. And the fourth is sanatana dharma. When you talk about dharma, at least you must clarity about which dharma you're talking about. Swadharma is very well illustrated in the epics, particularly in Ramayana. Lord Rama and Sita and Lakshman. You heard about it. Think of what does ultimately he say. It's Swadharma, it is Dharma. What is Rama's Dharma? I can't go into it in detail. But defined as Swadharma. In Mahabharata, Swadharma is defined as Kuladharma. You are Kshatriya Arjun, Mahapalesu Kalasana. Your job is to do the duty and not to emphasize or expect any results. So Swadharma is one thing, Jati Dharma is another. Samanya Dharma is a custom of the Shastras speak about 2 kinds of achar, sadachar and shistachar. Sadachar is the custom of the wise, and shistachar is the custom of the disciple, with a guru or devotee, with a god. So Swadharma, Samanya Dharma, Apad Dharma is the third category. It's the dharma of emergency, where you have to follow, where you can justifiably depart from the norms. And Mahabharata is a case study of Apad Dharma. Particularly the Dharma Yuddha of Mahabharata is Apad Dharma. So there is natural law as a word of God, natural law also as a word of reason. It is pious interpretation of the divine commandments. You might be surprised, but it's a fact. And I've read the original commentation. But in the early part of in the Middle Ages, there is no feminism. The Imams and the commentators on Islam said this about the verse on polygamy. Normally you understand the verse in Quran Sharif on polygamy as to prohibit, as to permit polygamy. Oh, sorry. What do you say? Marry ye 4 wives, if ye can treat equally. And before modern feminism or contemporary feminism was born, men interpreted for 2 centuries in Middle Ages this verse. And they said, we're not going to concentrate only on the first part, but the second part is very, very important, even more important. The second part is if you can treat them equally. Now, how do you treat 4 women equally? One is old, one is young, one is not so good looking, other is a stunner or whatever. One is educated, other is not. So if we can treat them equally, we have to obey Allah, but we must, according to pious faith, it's called pious hermeneutics, making sense of what the God meant, but in a pious way. So they made interpretation, it went to the second part of the verse. If ye can treat them equally. And there is the question, what does the Allah mean by equality? Right? Does it mean conjugal equality? Does it mean equality of esteem? Does it mean complex equality according to qualifications and appearance and all that? What is treating people equally? And what is treating spouses equally? And they showed that this kind of equality among four wives is impossible. And then they went to a verse in Quran which said, the Allah does not command the impossible. No injunction of Islamic law can be said to permit the impossible. Therefore, they said polygamy is prohibited. Way beyond contemporary feminism, way before Shabano. This is the history of interpretation. So, in fact, what I'm saying is, don't let me get away from the theme. The main theme was that law was not stationary, it changed, it's a place for interpretation, pious interpretation, and there can be difference of opinion. So, reason gives rise to interpretation and disagreement among interpreters and among followers of religion. So not first is word of God, second is law is based on human reason, which might be pious interpretation or secular interpretation. I read a stunning book by a friend of mine who wrote in the bicentennial of American Constitution. He wrote a whole book called American Constitution or something. I forget the title. And he said that a book begins by saying there are two types of interpretation of American Constitution. One is Catholic and other is Protestant. They are both Christian, but the interpretation varies according to the interpreter and according to interpreter's faith. Right? So that's very important. So one is divine commandment, second is reason, and therefore law was shot through with morality in natural law. That's the short point. Comes positivism, legal positivism, and you don't know all that. I looked at Lilly, you know all that. Legal positivism said essentially that law is based on what John Austin called positive obedience, habitual obedience. To whom? To sovereign. And how was sovereign defined? As you know, sovereign was defined by two marks, positive and negative, in Austin. And what these marks are about? Mark number one is that a sovereign is a person or group of persons who is habitually obeyed by bulk and generality of people. I'm quoting him. That's what he said. So law is not the word of God in positivism. Law is the word of collective men, monarch or a parliament or judges, community of judges. And from this is followed the second proposition they made was law was separate, unrelated, different from morality. In other words, laws are moral, beyond morality, beyond moral judgment. Law was the function of sovereign will. And even when the accepting parliamentary sovereignty, sometimes, many times, British judges deferred, differed from the sovereign and made their own law. The common law begins with the famous dialogue in the early 16th, 17th century, early 1600, first decades of 1600, where Lord Coke, we in India call him Coke, something else, I don't know. But you understand, Lord Chief Justice. Lord Chief Justice Coke said to the monarch, who was James I, I think, small memory for tyrants, right? But I think I'm right. Coke said to Lord James started to decide disputes. He said, monarch, I can decide disputes. Why should you go to the judges? And the judges said they were in the stage of divine right of kings. You couldn't say too much against or taking away from the divine right of kings. So the judiciary kowtowed to the sovereign will. So, my lord, you are vested with kingship, with divinity, divine right of king. But there is one exception. At the beginning of judicial review in the English-speaking world, what did they say? They said the following. He said, the following. He said, there is nothing beyond you. God speaks to you. But there is one small thing. And what is that small thing? And when people talk about artificial intelligence and the law, I tell them, please look at the dialogue of Chief Justice Cook and James I. What did Cook say then? Lord Chief Justice Cook said, you can do anything and everything because you are a monarch, and monarch is a spark of divinity on earth. We respect you. But there is one problem, teeny problem. One problem is that the law deciding disputes often means following precedents. Following precedent is just decision. Ignoring precedent is unjust decision. And the knowledge of law comes by hard study and reflection over generations, many minds. And therefore, law has an artificial reason of its own. That's what Cook said in 17th century, early 17th century. Artificial reason. This is what we are now talking about all the time in AI and the law. Not acknowledging Cook, it goes so far back. So anyway, point is they regarded law as a moral. They regarded relationship between law and morality as contingent and not necessary. Law can be clearly immoral, but it's law, it's king's word, and it's followed. But bits and pieces of judicial review here and there, which may question it under common law. We have in our constitution more elaborate system, fundamental rights, federalism, basic structure, and whatnot. But in the positivist system, judges only declare the law. They have no power and they should not make the law. Article 141 of the Constitution says the law declared by the Supreme Court of India should be binding on all courts in India. Okay? But indirectly binding on everybody. What the court says is the law. I interpret Article 141 of the Constitution differently. I say, and this was said by Hans Kelsen a long time ago in his pure theory of law, that You cannot declare the law unless you make it. You make the law and then declare it. And that is binding. But impossible to say what the law is, to interpret what the law is without making it. And he gave me, I worked with him for 3 years in Berkeley, not privileged. I saw him every Saturday. And he told me, son, please remember this. In order to say that X and Y rule nisa is granted, X and Y is separated and not married any longer, the judge has to concretely decide a divorce suit proceeding. The general law does not say X and Y. General law said Stuart, these are the grounds of divorce and so on. I won't go there. But the specific law, X and Y are no longer married, determining the status, is also law, the concrete law, in a particular dispute. The concrete law can be as amoral as the general law, according to legal positivists. He simply said the rights of persons, the right of Article 21 or Article 19, whatever you choose. Okay, so law does not have to be moral. That was the main idea. And judges only decide dispute. Herbert H.L. Hart went little differently. He's also a positivist. But he said this idea of habitual obedience is nonsense. Criticizing Austin is nonsense. It is more reflexive, habit than habit. Habit is a habit. For example, you turn the newspaper pages, some people look at the sports columns, pages. Some people look at politics first. Some people look at fashion. Some people look at what the stars foretell first. If you ask the person, why are you not reading the newspaper continuously, page 1 to page X? Why do you first look at this or that page? Obviously, the answer is habit. And this is not how. There is no law following habit. It's reflection. What will the court do in case I violate the law? Find me or send me to prison. Send me to prison, I don't want it. I want a short sentence or a large one. Or I shall hire the best possible lawyers and get myself free of all charges. Law always a matter of reflection. Reflexive obedience, not habitual obedience. The lawbreaker decides which penalty to take if established beyond reasonable doubt. The lawbreaker hardly comes into the consideration of what is law, or how law should operate. But lawbreaker arranges things in such a way that he or she is not caught. If when she is caught, she has defenses of all kinds, and reasonable certainty can be proved. And in order to counter these probabilities or actualities of behavior, certain laws, for example, are so strict as to deny idea of bail, like UAP, because offenses are listed there, scheduled offenses. That you make indirectly bail as a denial of bail as a kind of punishment. Whether it's legal or not, whether it's jurisdictionally sound or not, I don't go into that now. People have different opinions. I expressed my opinion a couple of times in the Indian Express, for which I write a column. You're welcome to look at it. So then comes token. I'm just reminding of what other people have said. I probably already know it. He said law is not a matter of rules at all, but habitual or reflexive. Law is a matter of principle. You have a big book called Law as a Matter of Principle. That is the principle of the thing, law, that matters, the purpose of law. And a hypothetical judge called Hercules, who decided tough cases. Or you can go back to Solomon, go back to Manu, whatever your favorite person is, and see how Manu devised distinction between Vyahvar and Dharma. That truth, Vyahvar. In fact, the early editions of Delhi Law Faculty Journal, when Dean Sivasubramaniam was present, at that time Dean did not change every 3 years. Dean was there for life. When they get fashionable, they go off. But Delhi University said, no, we should change, rotate the position. So this Sivasubramaniam, the first few issues he presided over Delhi Law Review were called Vyavara Nirnaya. Decisions according to Vyavara, not Dharma. Practical reason. If you look at those issues, I don't know that University has it, but I maintained a collection when I was dealing there. So idea is value-based justicing. Justicing is not value-free, it's not neutral. It reflects social values, it reflects personal values. So law and morality involves value-based justice. So I would now go to the aspect of conflict between law and morality. Okay? Before I come to the second thing. The conflict is several times, but I will I will look at only at conflict between public morality and constitutional morality. One is CM, other is PM, public morality. I'm not a politician, so these things, CM and PM have different meaning in politics. I'm not there, please. I'm talking about CM is abbreviation of constitutional morality, and PM is public morality. And with a trilogy of cases, you might remember, Nas, Kaushal, and Johar, right? In Nas, this conflict was solved by recognizing the rights to be sexual difference. They choose your own identity, whether a man or woman, or they call it, bisexual or non-sexual, whatever, polysexual, trans, and Johar. Now, I've not written on Johar, not because I'm not in favor of the outcome. Just incidentally, I've not written. I support the outcome. But that thing, the decision was based by Attorney General's concession that may your lordship decide. Concession means you say to judges, may your lordship decide. I have nothing to say. The state does not espouse any morality. Hey, we espouse. I'm sorry, I always very careful about feminism and speaking correctly. So we have to find a word different from espouse. Sorry, I used the male chauvinist expression. Please forgive me. In fact, when I was teaching at Washington, D.C. Law School, I told my class I have to take a seminar for 4 weeks, 4 months on comparative constitutional law. If you find me making a sexist observation or name, please raise your hand. And to the last lecture, everything was hunky-dory. Nobody raised their hand. I raised their hand for other purposes, for questioning or commenting, interjecting, but not for lapse in feminism. When I used the word, I said, why are you raising your hand at the end of the class? 4 months have passed. They said, we won't allow you. Why? They used a sexist expression. You told us to raise our hands. And the whole class went up. What expression did I use? Lawyers use it frequently, judges use it frequently. Expression is rules of the thumb. So I said, what is anti-feminist about this word? I learned from you. Tell me. They said you might find out for yourself, but it's a sexist word. So in the evening, I phoned New York. My friend, a legal historian, was sitting there. Prof. Baxi, I think was his name. I said, please help me. I have a problem. The class is saying I'm sexist. He said, which world are you living in, Upen? Which world are you living in? In Victorian England, a man, that is a husband, had a right, legal right to beat his wife, provided the diameter of the stick, the radius of the stick did not exceed a thumb. I didn't know it. And I apologized to my class. So I apologize to you for using the word espouse. But that's for the passing. I have not written on Johar because it was based on concessionary jurisprudence, I call it. Where the state says I have nothing to do with the matter. The very lordship decides. It's only a matter of trans rights. It was adjudicated, not adjudicated, it was again the same thing, may lordship decide. But marriage equality, intersex, Parliament even passed a bill about transgender rights. But the gays and lesbians, the intersex, they said nothing doing. We oppose this application. The result, it went to the chief secretary of the cabinet secretary to tell the court what they were to do. In that intersex marriage decision, marriage equality decision, the cabinet secretary has yet to report. So there is CM, conflict between CM and PM, constitutional morality and public morality, which occurred regularly ever since Nas, through Kaushal, through Johar. And the first two were judicial decisions. The third is a judicial decision for which we're waiting, because ultimately it has gone to the cabinet secretary to decide how far Personal Marriage Act can apply or should not be applied, and it's a complex matter, to this gay marriage equality concept. So in a sense, I here end my discussion of constitutional morality and public morality conflict. There is one which says constitutional morality is different from conventional morality, and therefore constitutional morality should prevail. This was the view taken in Nas decision. Consenting adults may perform homosexual acts in private. Is no longer criminalized or illegal. But other things, other forms of discrimination may still continue. Only you cannot decide the question according to my sexual preference, orientation. I may have different sexual orientation. Most people have heterosexual sovereignty, believe in man and woman. But I may not believe in this identity, I may believe in some other identity. I have a right to identity and to manage conflict of identity in case of bisexual persons or other persons. So my friend Venugopal always opposed this idea. And in fact, Venugopal was the Attorney General. He gave Lala Sanjeev Memorial lecture and said there are two dangerous things for future of India. One is basic structure and other is constitutional morality. And I was probably chairing the occasion. And I said, when this will not do, we must give him a good reason to take us all night to get to Keshwana Bharti, which decided 68 days. Took 68 days of hearing. This is decided much later. Anyway, he kindly said he would leave the constitutional morality aside, but that basic structure should go. Now the question arises, what is basic structure? It is ethics that apply to power. That's basic structure. You can read that book that your university has published on Keshwana Bharti. And your present Vice Chancellor worked very hard, I must say. So please, don't run away with the idea that basic structure is wrong. It is applied constitutional ethics and theoretical constitutional ethics, that there should be some limits to power, and that Keshwananda has evolved, doctrine has evolved, what is basic structure, what are essential features, I won't go into that. So here, as I promised, I should end abruptly, because I've taken a lot of time on the first part. On the second part, if you have 4 or 5 minutes, just make a few remarks, and I'm not got notes on that, but the second part was law student and academics, as we look into aptitude and accomplishment. I would rather have you talk on this. But I will only raise the question, where does constitutional morality enter into this discussion of aptitude and accomplishment? Do we judge, should we judge at all legal professionals, would-be legal professionals, by standards of constitutional morality? That's the question. But I leave now, and please raise your, I don't know how to operate this chat box and all that stuff. I'm sorry for that. So whoever is comparing this, please make sure that the speaker announces himself or herself and puts a question or comment as they like it. I would do as far as possible to respond to this question. Okay? So that's for the time being. Ma'am, all up to you now.
Sir, am I audible?
Yeah.
Am I?
Yeah, I can hear you.
Yes, sir. Thank you very much, sir, for the profound and thought-provoking lecture. Your words have opened new avenues of understanding for all of us, and I'm certain that many of us are leaving today with new questions and new ways of thinking. With that, we now like to move into an interactive segment. We will now open the floor for questions. Students and faculty members who wish to engage with Professor Baxi may kindly raise their hands.
Good morning, sir.
Good morning.
Sir, I want to understand something from your experience. If
Yeah.
someone hopes to reach an academic leadership position early in their career, what should they focus on during law school and in the years right after?
Oh, that's a
To
big
figure-
yeah. Tell
I am
me.
trying to figure out what habits, skills, and choices really matter if the long-term goal is to eventually lead a university at a young age.
University at a young age. Yeah, that's right. That's a question. Yes, I think the word young is very important. I think, I think you're asking this question to a fossil, but I was invited. I was invited to lead the Delhi University when I was teaching in Sydney, and I don't know what Delhi University was. I never studied in Delhi. I studied in Bombay, and by all standards, I was probably the youngest professor, and to be invited to a university. And then I became the dean within 1 year. And then I became director and vice chancellor and all this at a fairly young age. So the question is very important. Um, I think that there are no universal prescriptions um, because everything occurs in a context. And context does do two things. It liberates and it restrains. So if you happen to be in a deeply caste-oriented society and culture, there are some things you can't do, even as leader. For me, equality is very important. One of the things I did in my life was to make sure that there was no anti-discrimination based on ability, and based on sex or gender, based on human beings and non-human beings. Any kind of discrimination was out and is out. One of the things one looks for when one is young and taking charge of the university is to look at equality in action. Nobody should be discriminated against on the basis of caste, creed, color, faith, sexual orientation, ability. I go around the country and find me those able people like us do not even see disability, perceive it a problem. And this is very sad. You go around the country and find in the faculty what kind of disabilities are practiced, what kind of discrimination are practiced. You will have very few what previously called handicapped people in the faculty. Why? Although some people might have got gold medals and took first class first, because of their disability, they are not given prominence or admitted to the faculty. How many disabled people are members of faculty India-wide? Please provide me the statistics. How many women there are? The different class. How many untouchables, so Dalits there are? So partly I respond to you, as a young person in charge of faculty, one would expect you to abolish discrimination on all grounds. We are all human beings, and Article 14 and 15 and 16 of the Indian Constitution ask you to follow complex equality. It's not equality which is simple one-to-one. It's a complex, many layers of inequality. Our Supreme Court, through Chief Justice then Chandrachud, spoke about intersectionality. He didn't have time to pursue this concept, but it opened the door. And what is intersectionality? Intersectionality is a cascade of disabilities. One might be an untouchable woman who is disabled. 3 in 1. Untouchable, you're discriminated against, Being woman, you discriminate against. Being disabled, you are discriminated against. So your disability is threefold. Now, as the enterprising young person leading the faculty, if you do not practice complex equality, if you don't pursue equality among sexes, abilities, and other kinds of discriminations, go on, caste, then you continue the same tradition as exists before. I'm not going to advise anybody, but at this much I would say. In fact, Greek philosopher, political philosopher, I forget his name, you find him on the net, had a notion of isocracy. It's a Greek word. Isocracy is complex inequality or equality. And democracy is only, I add a footnote to his work, democracy is only worthwhile if it attacks or promotes equality, attacks inequality and promotes equality. It becomes a society, isocratic society. Now, ours is actually isocratic if you're 14, 15, and 16, and many parts of the Constitution. Secondly, as a young person heading a law school, or the second qualification stems again from the Constitution. There is a little paragraph called Part 4A of the Constitution. There are only two cases on it. Therefore, we who teach case method of law and all that, won't teach that part. We don't tell we edit away the Constitution. This is not relevant for Constitution. There can't be a greater mistake than that. Article Part 4A speaks about the fundamental duties of citizen. And introduced the emergency of 75-76. Less said the better about that. Unfortunate internal emergency. There was no justification for it. But the duties have not been amended by any regime. It's true they're tainted in origins by emergency. After emergency, many regimes came until 2025. In fact, one more duty has been added to 10 earlier 10 on environment. So 11 type of fundamental duties. One of the fundamental duties, I don't know, I don't want to speak long, but one of the fundamental duties is, and please note it, I think F or something, 41AF, but I may be wrong about the last one. We say every citizen has the duty to develop scientific temper, spirit of critical reform, and excellence in all walks of life, singular or collective. Mark the words, singular or collective. What are duties to develop scientific temper, spirit of critical inquiry and therefore change, and excellence. Now let me focus on excellence only, merely, in the want of time. I used to ask my class when I used to teach that, nobody taught fundamental duties. But anyway, I used to do that. And I was allowed to teach constitutional law because I had worthy colleagues. I formed the education committee when I had 3 subjects to teach. And I had little done Boston, then I had written on Constitution. So, and I was dean, to bypass with 3 preferences, passed me once, twice, 4 times. 5th time I said, please do at least let me know. He said, Baxi, you can't teach constitutional law. I said, why? Just tell me, I will not ask again. He said, you did nothing. I was thoughtful because I've been proud of article little done, Boston done. Many judges have followed. In fact, Justice Chenapalli introduced to me once in 70s, late 70s. He told me, I'm very glad to see you, Professor Baxi, because I've read from cover to cover so many times your article on Little done, Boston done, the Journal of Indian Law Institute. And every time I sit on the bench, I remember it. It's a high tribute, and I'm very pleased I was a young person then. But that's not the point of the story. The point is, as a as a as a young person leading an institution, the second thing you do is to follow your fundamental duties. And ask everybody to follow the fundamental duties. We don't need fundamental rights, as a matter of fact. It's a bigger chapter. Part 4 is one paragraph. Whether you like it or not, it's your duty and mine to develop a spirit of excellence. And I used to ask my class when I was teaching, that was many years ago. I used to say, what is the opposite? Avoid the tyranny of singular when you teach. Always think in pairs. So what is the opposite of excellence? And slowly the answer emerged, mediocrity. Mediocrity. So we have a constitutional duty to avoid mediocrity. Right? The duty, yours and mine, in whatever we do. We have to develop excellence. A mediocre teacher is no teacher at all. He teaches from the old notes and old things, who doesn't read cases, old statutes, who believes in wisdom. India is the only country, for example, where judges appoint judges. Can't be anything. There are 4 judges' cases. I've shown it in the article I wrote for your Assam Gawati law book on Keshwan Bharti. I've shown it there. Please do read it. It's your own publication. I've shown it and nobody has read the 4 judges' cases, word to word. I proved it. But go to classroom and express your opinion, everybody claps. India is the only country where judges appoint judges. Nothing can be further from the truth. Now I've shown why, I won't go into it. So, to avoid shortcuts, to learn to read in extant fashion, slowly. Don't go by what the AI chat box tells you. My God, the shortcuts to so-called knowledge are infernal. To put it mildly, I don't have words to go further. I won't go further. So these are the things that one might do. You may disagree, but this is what I think one or two things that one may do.
Thank you, sir.
Thank you.
Good afternoon, sir. My name is Shivani, and it's an absolute honor to be conversing with you at such an early stage in my life. I had a question for you, sir.
Yes, please.
Sir, I'm just in the first semester, and we keep hearing different views on what we should do, such as a young academic, and to make a difference in the early career as whole. So you are the experienced one in the room with us. I want to know something which is intrinsic to your lived experiences. So, sir, should we focus on making really renowned publications which have actual real depth, or actually we should focus on building like consistent work and a list of consistent work to be more accurate?
We have to, and you mentioned, Shivani, when you mention work, you mean articles and writings or?
Yes.
Yes, okay. If you mean articles and writings, I think so many things can be said, and you know many of things already. because your question is framed on the basis of experience and concern. First general thing I had practiced in my life and I found very useful is to try to learn to read slowly. And this I go back to Jawaharlal Nehru. He said in a different context, and we were young urchins, and radio was the innovation of the century that time. And we were not allowed to touch the radio. Our parents would control the volume, what program to hear, and so on. So we said nobody objection to Nehruji speaking live. So we were very small, and he said, he followed him Hindi. He said, Chale. And he had a famous habit of pausing for a long time. So words came very slowly. Chale.
So I would like to intrude just for once.
Yeah.
So you say that we should read slowly, right? But the fast life which we are living as youngsters, as the Gen Z generation, and the entrance exams we also give, we have to read faster to be a part of this system.
No.
We cannot read slowly.
That's where illusion is. That's where the problems arise. For reading fast, in my opinion, is no reading. You miss out on many things. Therefore, you have to read it. I think first thing is slow reading. So Nehru used to pause every time and say, Chalo, then you put 10 minutes, 5 minutes gap, then say, Giro. After 10 minutes, said, Utho. After 10 minutes, said, Chalo. This is slow reading. There is no option to slow reading. So in India, in all national law schools, apart from the group called Spicy, which had a blog on intellectual property rights, very few people in India read cases word by word. I've not met anyone who has read Keshwarana Bharti even once. I read it 22 times. And each time I discover I'll miss something up before. I've read slowly, not the computer generated summaries. At that time, there was no computer anyway. So I think there is no escape from this. The world may be moving fast, the internet may be moving fast. For example, unless you understand, there were two decisions in NJC case. I've written in my article. You can have a look at it in Keshwarana Bharti. The first NJC case had two sets of opinions. One was about recusal. 5 judges wrote about recusal. And second was about judicial appointment, National Judicial Commission Act. You miss it. But judges don't miss it. Judges know them, live lawyers who argue both sides of the case. So what happens is, if lawyers don't read cases and statute, tell me carefully and slowly, who else will in society? Management, science, sociology, anthropology? No. If we don't read statutes and legal materials carefully, judgments, nobody else is going to read them, excepting judges who have developed law. There's enormous normative labor, and that requires a minimum courtesy. For example, it took 68 days of argumentation to generate the decision in Keshwarana Bharti. Maybe you don't have 68 days. But then you don't say you read it. You read the ratio. Where is the ratio in Keshwarana Bharti? That one. So, and it's a fundamental case. I said about the Keshwarana Bharti in 1974, 1 year after you decided I tried to come to Delhi or to Sydney. I said, my first sentence was, Keshwarana Bharti is the future constitution of India. And that's what happened. Why they were able to say it? Because I read page by page, paragraph by paragraph, and did not read the head notes merely to get that. So I think it's important, no matter how inconsequential it may look to you, at this age of speed, to read slowly and carefully what you're reading.
Totally, sir. Thank you so much for your insightful answer. Thank you.
No, I'm
I'll
sorry.
keep that in mind from now on.
I'm so sorry about this. But I know there are tools available on internet which tell you what is. They always ask you, do you want somebody? I don't use ChatGPT or I don't use social media or computer programs to decide what to read. If I don't have time, I don't read it. But I absolutely mum about it matter. I don't know. I'm not ready. It's very important to not to say what you think about the case without reading the case. Very important. In fact, Carl Willen, professor at Chicago University, a great man, American realist, used to teach first semester classes. And somebody asked him, "Sir, why are you doing this? You don't have to teach LLB, you teach LLM, take on a PhD." He said, "No, son, I do this because I love it. They're fresh minds, and I learn a lot from them. And secondly, you must, and this is what he said, you must look not at what the judges say, but you must look at what they do with what they say. Look at what they do with what they say. This is tremendous. You have to, when you wrote about cases, one case, intertextuality, what kind of materials they use. Justice Kerr in the fourth judge's case had a marvelous 20, 30 pages of 400 pages of 500 page opinion, in which 20 pages or so were devoted to the idea, psychology of gratitude and loyalty. Loyalty. Kindly do read it. Because he said judges are appointed by the executive at their will, at their command. These things are essential to know. When would you be loyal to a particular thing? You can be loyal to a cause, you can be loyal to a person. Right? And you can be loyal to an idea. So, and what has gratitude to do with loyalty? And it's fantastic. I didn't know this material from social psychology. I can only learn it through Justice Kerr's normative labor. Now, judges do so much effort. Minimum courtesy is required. You don't become ratio hunters. Just look at what the judges decided in the case, or the case decided. No, ratio is important. But ratio hunters, being ratio hunters, is to ignore the enormous normative labor the judges put in. So I can request you all to consider this. It's up to you where you want to go. If you want to show off your knowledge about cases and impress everybody, well, what is the limit? You can go to summaries, you can go to various legal tools that the laws have created in India, artificial using AI. Everyone has their own AI and program and modules and so on. I'm not reached that far. In fact, I'm a leading critic of AI in education and AI generally, but that's a different matter. I've written a number of articles, given a number of speeches. I'm very completely wrong, but the truth has an uncomfortable habit of lying in the middle somewhere, not the extreme. So maybe I'm wrong in going too far on AI, but they are also wrong in going too far. They deliver everything at instant speed. We deliver knowledge, information, knowledge and wisdom and pleasure, everything you want. It's a this clip at your command. That cannot be. Unless you believe with the famous computer analyst and theorist, cyber philosopher Ray Kurzweil, Ray Kurzweil does not use the word AI. Ray Kurzweil calls it singularity. Singularity is near. Was the book he wrote in 2005. In 2024, he wrote a book called Singularity is Nearer, where his thesis is by 2047, when you'll be around, I won't be. By 2047, rarely his prediction has gone wrong. He said by 2047, the machine intelligence will have superseded the biological intelligence. There are only 20 years window to think, to be able to think. Why not do this? That's my polite request to you. Why not use this 20 years? Because after all, the technological development is super fast. And if high people will believe they'll conquer everything, instead of some odd balls who will worry about reading slowly and so on, most of the world is fast moving. And Kurzweil propounded the law of acceleration, speed, 25 years, 24 years ago. He never is his professional. And there was a man who wrote a book called Vidilio. Vidilio wrote a book around the same time, 24 or something, 1980 or something. He wrote a book called Speed and Politics. Politics will also come, law of acceleration will come in, has come in. And he said speed, the Greek word is normology for speed, science of speed, normology. He said normology will overcome democracy everywhere in the world. This is what's happening. So if you are a normologist, a speed person, then you have no use for democracy. I would say no use of philosophy. They're a different world. Information is everything. And who, by the way, is peddling this information? Who is collecting this information? How this information is collected? And offered on a platter to people like us who don't tell you to think anymore. Machine learning is considered be all and end all. Human learning has no place. Fortunately, I won't live to see that day in my life. So that's okay. 47 is a long time away. Good luck to you.
Thank you, sir.
Okay, if there are no more comments.
Yes, sir, we have.
Okay. I'm here too.
Hello. Good afternoon, sir.
No.
I'm Aniket Jana. My question is not regarding today's theme, but on the climate theory, justice
Yeah.
theory that you have given. So my question is that the climate refugees are mainly, we can say that they are product of the Western countries, but the refugee issue is retaining on the global South. So who are this? Who are suffering doubly? Like they are also having the repercussions of the those climate changes, and also they are having the refugee crisis. So how does the climate theory, justice theory, is tackling this issue?
Well, thank you. I must first of all feed you with some information and come to and directly answer a question. To me, it's entirely misconceived, with great respect, to say that climate change and global warming on the Anthropocene is an imperialist Western thought experiment. Nothing can be further from the truth. Climate change arises, the protest against climate change and global warming arises for those people who are mostly at risk. It has arisen from the association of small island states in Pacific, like Kiribati, Vanuatu, and Vanuatu is the lead, but many others. That string of that sea levels are rising, and they are fated to disappear. So there is a certain urgency, and they have led the movement because they will be their territories, all Solomon Islands, a group of 1,000 islands or more in the Pacific. Even as we talk, some islands are being submerged because the sea levels are rising. It was they who brought attention of the rest of the world, not Western or Eastern or Southern thinkers. So that is point number one. The origins of the movement came from disappearing states people. They're going under the sea. And they have led the movement. Second, on the climate change theory, there is a lot of literature. And I won't be vain enough to mention mine, but I would say mine is a leading article in the Journal of Environment and Human Rights. And I send you, be glad to send you if you send me by an email request at baxi@gmail.com. That's easy to remember. If you can't find it, I'll send you the article and you can generalize it to other colleagues, which is on theories of justice. How can you apply the existing theory of justice, if at all? How can we apply them to climate change and global warming? And I examine the theories of justice. And the main problem there is, of the problem of justice is, how much burden you bear, how much burden sharing, how much burden, there's no benefit by global change, climate change and global warming. Who will share the burden of putting it right? 1.5% emission of carbon dioxide is the Paris pledge that is everybody should reduce. We are woefully short of that. Who will bear the cost of mitigation? Because the global problem is not a problem of one nation alone. Every nation. Extreme weather conditions affect us all. Drought, desertification, accelerated destruction. All these are happening. The last summer in Europe was unlivable. That was because of climate change. Similarly, this international laws are basically studying the disappearing states. Talking of sovereignty is blasé. People are thinking about how to survive. So they're thinking about international law of disappearing states. The foremost question in climate justice theory, on my analysis, is how shall the collective endeavor of mitigation and adaptation, which costs money, what sharing will occur? And the Paris Convention on Climate Change laid down a wonderful rule of justice, in my opinion. And that is common but differentiated responsibilities. They are all common responsibilities, but the polluter pays more kind of thing. They are differentiated. So in advanced countries who are the root cause of climate change should assist other countries who are now at a disadvantage because of carbon dioxide, because of the coal mining, because of the industrial revolution. They are now in the fourth one. Everything depends on using nature and natural elements to manufacture and to produce. And the pollution then causes in Delhi, yesterday in India, You're lucky you don't have that problem. In Delhi was choking. So every year, the Punjab and Haryana farmers traditionally put fire to their farms so that they regenerate for the next year's crop. That's the belief. And all this smog comes to Delhi from Haryana and Punjab to Delhi and North India. And people, you were right to breathe on Article 21, but people actually die in that period because they can't absorb so much pollution. So you have a problem, common but differentiated responsibility. And second principle of justice is how much the compatriot, that is how much the people in one area should pay to the non-compatriot to develop the technology and the wherewithal to fight climate change and blah, blah, blah. It is not easy at all. It is, and growing daily. Burden is growing daily. We also pollute our own environment. Look at the deforestation rate in India. How much forest is being cut down for so-called development. Development is necessary. Our constitution says development is okay. It's an important part of constitutionalism. But under Part 4, development, which is just development, is development. Unjust development is no development. So there is a conception, constitutional conception of development, to which I won't go, of sustainability. Even if the word of sustainable was common, became common 40, 50 years later. The Constitution, right to principle, talk of sustainable development. First in the world to talk about. They don't use the phrase, but they mean what today we mean by SD, sustainable development. So in fact, there are theories of justice which may extend to causation, harm, for example, causation of harm. Which set of countries is more responsible for the global harm that is caused? What duties they owe to those they have harmed? Do their duties extend to compatriots paying for the non-compatriots? Compatriot means citizens of one nation paying for another nation troubles. To what extent should they pay? These are live issues. I'll send you an article if Professor Sharma, and we might have a authority group. Yeah, and you can. I've given a lot of references to literature there. So the Paris Standard, Paris Convention says you must share responsibility in common, or it's a global problem and a historical problem. If the Industrial Revolution had not occurred in the way which occurred, there would have been less pollution. But conception of development which will destroy nature, which cannot be replenished. And these are consequences of industrialization. Large literature on that. I refer to all of that in my article in the Journal of Environment and Human Rights, Oxford University Press is bringing out every quarterly. Kindly have a look at it. There are other articles about environmental justice, if you are, but it's a very severe problem. We are already too late. In the law school, is there a course ever on anthropocene and the law? I've insisted when they invite me to visit them, I talk only about one thing. And I have a four, and Nalsar has my first course towards injustice anthropocene. On the website, you can look at it. But every university has made the mistake of inviting me, has suffered from a course or seminar program on climate change and global warming. Because I think when you think of lawyers you're producing for the next who go to practice in what 20 years, 15 years will be prominent lawmakers or lawyers by 20 years more. So you're teaching for one generation at least. And we don't have one generation. Climate change, according to many sources, is moving so fast as to destroy the whole earth and all species. But no law school has gone so far as to have a program on climate change and anthropocene. I sincerely hope I'm wrong, but they would like me if I was wrong on my information. I've given courses which are on the websites in NASA and many other places on climate change and the law, global warming and the law. And just I've done for Keshav on the Bharti case, 2 things I've done. So I think there's to be a very close study of what happens, what has happened, and what future has in store for us. And disaster relief law, which has come in its wake, is a very little feeble answer to this idea of climate change. Now, study India's governmental policies on adoption and mitigation of climate change. The measures they've taken, they're worth studying. For example, rainwater harvesting is done by the present government, which is a very good scheme, where the rain used to fall and go into the gutter. How that excess monsoon water can be used, or how can solar and wind energy be used. The Indian government has taken very many good initiatives to prevent extreme weather conditions, to prevent pollution, and all this has to be studied carefully and suggestions given for future. But already it is too late. But whatever we can do, for example, if Bangladesh goes under, or Sri Lanka goes under, would we absorb the migrants? It's easy to talk about responsibility in common, but practically, your own population to care about. There are many cities in India which will disappear, and set of disappear. They are coastal cities. Bombay, the Arabian Sea, Calcutta. What's the planning we should do? What sort of planning we should do? And is being done to save these cities from disappearing because of temperature rise? These are very urgent questions. And how does law enter all this? It's very important. But the law schools, please correct me if I'm wrong, and I'd be happy to be proven wrong. Law schools turn a blind eye and a deaf ear. Despite my evangelism for that, I don't know why. I hope we will start one. And there is a lot of deforestation in Assam, a lot of unseasonable weather conditions. We are all victims of these changes. Unusual flooding. So these are matters of great importance, and we should think of study governmental initiative, non-governmental initiative, people's initiative, and legal initiative. And there are Supreme Court judgments which developed first time. It has developed theory, indigenous theory of intergenerational justice. It's a very good judgment, which creates a fund for the future. There is no ombudsperson for future generations. We don't worry about future generations. We are so worried about our own. We should be worried about our own generation. Father, mother, and grandmother, mother, daughter, grandmother. We should worry about that, 3 generations. But worry about 3 generations also includes concern for global warming and anthropocene, which you become aware There's a lot of material on it. The place of law in Anthropocene, whether it's important or it can become important, is very important. International law certainly is important, but national law should be in accord with the international law. Is it? Is it or is it not? What more we should do? These are questions we must pursue. So let us hope that your law school and your initiatives become the pace setters for such type of programs and courses. Let us hope the NSS picks up this seriously also as a public cause. That's all I have to say for the moment on this, but I can occupy the whole week speaking about it, so I won't do that. I won't do that.
So, yes, firstly, just I want to inform just one thing that yes, NLU Assam does have a environmental center, so where all these issues are being talked about.
Oh, very
And-
good.
Yes, and secondly, I am an LLM student, so mostly I have done my 5-year law course from a traditional university. So I can tell you that in those cases, yes, the universities are turning a deaf ear to these environmental issues. So there's that.
Yeah, but we must do a distinction, as ancient seers drew a distinction between dharma and apadharma. Apadharma is dharma in the times of emergency, of which Mahabharata, as I said, was a brilliant example. And Samanya dharma is for business as usual, you carry on, and what are the duties of the householder and one after another. I'm glad that environmental law is important, but it is not the same. The pollution reform, the pollution boards now, and you can study them. You can study desertification, you can study seasonal weather separately. But when you bring it under the idea of global warming and climate change, it is seen to be a common problem all over, regardless north, south, or east, west. And an urgent problem. It's not something that you can include. Environmental law is quite different from this apadharma, the emergency that is staying in environment. Environmental law is, yes, very important. Sustainable environment. I hear about it. I don't know what sustainable is. In fact, I was reading a book a couple of years ago, it's the 5th edition. You might have read it, by a woman, I forget her name. I'd come back. And it's the 5th edition called Environmental Law. And it says in the first or second chapter, it is a sustainable development. And she lists 75 definitions of sustainable development. Now, if a phrase like sustainable development has 75 meanings, and each one is important, the field is doomed. Doomed. Beyond redemption. And a matter like sustainable development, it is not business as usual. It is not business at all. It is moving at unusual speed. Do we show that? The big question. Does the world show it? No. Other things matter. You all shop at malls, don't you? Or you have this home gift workers, platform workers, they work in 5 minutes, 8 minutes, they get the food you want. Do you ever know about the environmental harm that business entails? When the malls or gig workers, they are conventional environmental harms like forest burning. There are modern environmental harms. There are post-modern environmental harms. There are traditional, conventional, postmodern, modern, postmodern. There are colonial harms, there are post-colonial harms. So I think we don't have a typology. There are necessary harms, there are unnecessary harms. Environmental injury is not merely something called fancy called sustainable development. Oxymoron. Huh? Oxymoron is a sentence that does not make sense. Similarly, they're buxymorons. BAXI, buxymorons, myself, which make no sense at all. One of the statements I often make is that sustainable development can only be thought of when one does unsustainable thinking. Sustainable development cannot be pursued by sustainable thinking. You need to go to ancient traditions to find modern solutions. How they treated land as a motherland, Panchamama, mother, land is a mother, not as a warehouse, not as a resource that can be endlessly exploited. The thing I'm sitting on, and you are sitting on, chairs, tables, you know how much destruction of. I have a water bottle here. I haven't used it, but look at it. Amount of plastic that we use daily. So environmental law is all right. What is required is a change in the system of production, a fundamental radical change in in the cycle of consumption. Our ways of using things should have to be changed. It is not just a problem of states and governments. It's a sustainable development, just sustainability, escaping the effects of Anthropocene, is a problem of change in lifestyle. And how many us as individuals are prepared for a change of a lifestyle? Very few. And if you cannot undo the harm that millions cause, just pure arithmetic. Right? So it is. I'm not taking off the hook the states and the government, and the global politics, certainly. They harm the environment. But by being good consumers, we harm the environment more and demanding more and more the same thing, same pollution. Now it is true that there are less polluting vehicles, for example, electric cars that are produced, something called green technology, and it's something called rain harvesting, something called solar and wind energy. All these are developed by the same corporations which create the conditions of harm. Where do you go? All the techno fixes are produced by the same corporations, a group of corporations. When CEO, it's open corridor, move from one to another industry. They are the same people who produce pollution, and when it crisis, they are the same people who will provide us with techno fixes. We live in the world of techno fixes by techno managers. We live in a world of technology. But it is basically a problem of lifestyle management. So we can tell the state to perform X and Y duty, we can follow the government to work P and Q, but we also have to perform our part, our share, which is the hardest, change in lifestyle. We don't do it. We don't even countenance the problem. What you've done?
Thank you, sir.
is-
And
yeah,
yeah, thank you for this. And also, I would love to read your article that you mentioned earlier.
yeah, send me the. Then I generalized. I sent it to our friend in the ancestry, and then you would look at it. Yeah.
Okay, sir. Thank you, sir. Thank you, sir.
Are there any more questions?
No more questions. No more questions.
So, as we move towards the conclusion of today's program,
Thank
I
you.
now request Saksham Patiar, convener NSS Unit 2024-25, to deliver the vote of thanks and formally bring this session to a close.
Thank you. Thank you. On behalf of the NSS Unit NLUJA Assam, I deem it a privilege to extend our profound gratitude to our esteemed guest, Professor Dr. Upendra Baxi, for delivering an illuminating and deeply insightful lecture. We are truly honored by your presence, sir, and deeply appreciative of the time and wisdom you have shared with us. I also place on record our sincere gratitude to the Honorable Vice Chancellor, Professor Dr. KVS Sharma, for graciously facilitating and supporting the organization of this lecture. Our thanks are equally due to the registrar and the administrative staff of the university for their meticulous coordination and sustained efforts in ensuring the smooth conduct. Finally, I extend my heartfelt thanks to all the faculty members, students, and participants for your presence and thoughtful engagement. Thank you once again, Professor Dr. Baxi, for honoring
So,
us with your presence. Thank you very much, sir.
thank you indeed. Bye.